Never mind that he tried to block the January 6th committee from seeing documents that may have included evidence of his wife plotting the insurrection at the Capitol. He would never do something that is in his personal interest above that of what the law requires or sound legal reasoning requires. Confidence in the court is vanishingly low for good reason. The question is, what the hell is Congress going to do about it? And it turns out we are not powerless to stop this court's rampage against our freedoms. I can't help but think of Justice Thomas's glaring omission of another case, and this has been discussed to some extent today. And that case is a 1967 decision called Loving v. Virginia, which established the constitutional right to interracial marriage. It seems to me that following Justice Thomas's logic about reconsidering the court's substantive due process precedents, the Loving decision would fall naturally on his list. Now, my Republican colleagues would say that Justice Thomas's omission of Loving v. Virginia is nothing at all to do with the fact that he's a black man married to a white woman. Never mind that he tried to block the January 6th committee from seeing documents that may have included evidence of his wife plotting the insurrection at the Capitol. He would never do something that is in his personal interest above that of what the law requires or sound legal reasoning requires. Or what does it do to the reputation of the Supreme Court and to people's faith in the institution that justices like Clarence Thomas appear to be deciding cases based on their own personal preferences and political ideology rather than what the law requires?
Thank you, Representative Jones. I will note that this idea that judges deciding cases based on their own predilections is the very essence of the judicial activism that your conservative colleagues have denounced. I would like to perhaps call attention to the condescending sexism of this decision, which seems to view the choices of women as somehow illegitimate when they make them. The Supreme Court has virtually ignored American women with this decision, and the consequences will be startling and alarming.
Congress, in fact, has a breathtaking number of options to rein in the power of this rogue Supreme Court. In the past, Congress has deprived the court of appellate jurisdiction to issue certain decisions. It has expanded and contracted the number of justices. It has granted and withheld the court's power to issue injunctions and other writs. It has immunized particular types of defendants and executive actions from judicial review. It has suspended causes of action to bring certain challenges. And of course, it has taken other actions. I have routinely urged this body to take action to reform the Supreme Court, action that is desperately needed to meet this moment in our history. It's why I introduced, along with Chairman Johnson and Chairman Nadler, the Judiciary Act to add 4 seats to the Supreme Court.